Madam Clerk, would you open court, please? Yes.
The Honorable Chief Justice and Associate Justices of the Supreme Court of North Carolina. Oh yes, oh yes, oh yes, the Supreme Court of North Carolina is now sitting for the dispatch of business. God save the state and this honorable court.
The court calls in re E.J.B and R.S.B. We welcome you all to the Supreme Court this morning. This is the third day of our virtual arguments, and it's the first time in the court's 200-year history that we've had the opportunity to host virtual arguments. So we're so delighted that you all are part of these arguments today. Mr. Ewing? You'll also note that Justice Davis is not present this morning because he's recused in this matter.
May it please the court, my name is Robert Ewing and I'm with the Forsyth County Bar, and I represent the respondent father in this appeal. I would like to reserve 5 minutes for rebuttal.
You may.
The issue before this court is whether the Mecklenburg County District Court had jurisdiction over the juvenile proceedings in this case. There were two juvenile underlying proceedings. There was a neglect and dependency proceeding in 2015 and then one in 2018. Also, there was also a subsequent termination of parental rights hearing that was held. And so the respondent father has challenged on this appeal whether in fact Mecklenburg County had jurisdiction over this entire matter. Normally, state courts have jurisdiction. Each individual state has jurisdiction over its own child custody proceedings, including what we call our neglect, abuse, dependency proceedings, as well as termination proceedings. However, in the 70s, Congress became concerned that there was an alarmingly high rate or percentage of Indian children that were being removed from their home. So they enacted the Indian Child Welfare Act in 1978 through the Commerce Clause. Under that act, it set forth the minimum standards that are applied to the states in holding proceedings in which the federal statute refers to as foster care proceedings or termination proceedings. The statute that we're primarily dealing with is 25 U.S.C. 1912. That federal statute basically says that if a court has knowledge or has reason to know that an Indian child is involved, the court shall send notice to the Indian tribes to give them the right to intervene in the case. Further, the statute says that no further proceedings shall be held until notice is given and the Indian tribes have had a right to respond. Now, the facts of this case started April 7th of 2015 when Mecklenburg Youth and Family Services filed a juvenile petition alleging that the two minor children subject to this appeal were neglected and dependent children. On that same date, Mecklenburg County YFS, or Mecklenburg County District Court, entered an order for non-secure custody, granting custody of the children to Youth and Family Services and allow them authorized foster care placement. On May 4th, apparently from the record, a child and family team meeting was held in which the parents were present, and the respondent father indicated that he had Indian roots. A month later, on June 30th,
didn't he originally deny that he had paternity?
he did to the Youth and Family Services. He told the social worker he denied paternity. I do note to the court that he actually had custody of these children. I just direct the court to the juvenile petition on page 4 and 5 of the record. He actually had custody of these kids. He's been involved in these children's lives. So yes.
But did he, prior to this more consequential interaction that he was beginning to have with DSS, didn't he originally deny that he had paternity of the children?
He had, when DSS had been involved with his family for a significant period of time, and he did at some point deny paternity, but then he reversed course when the case started. In fact, the court found that he is the father.
Did that original denial of paternity at all, in your view, have any contribution to any notice deficiencies that you're claiming?
No, because the notice, it's triggered when there's an issue of whether the child is an Indian child, or the court has knowledge or has reason to know that the child's an Indian child.
The social worker claimed ultimately that there was not sufficient information that was given to the social worker by the father after the original denial of paternity. Does that contribute at all to what would be the dereliction, as you would see it, of DSS to be more involved in pursuing the notice requirement?
Right, that raises the question of whether the trial court has reason to know that that child is an Indian child. In some of the cases that I cited in my brief.
Before you get into that, can I ask you a quick question? You indicated in your initial summary that there was a team meeting in May of 2015, at which point there was discussion that the father had Indian roots.
Yes.
Was the court advised of that? And if so, when, and exactly what did the court know at that point, or what was the court told and when, I guess?
I'm not exactly sure when the court was informed, but there were 8 separate court reports given that were in the record. The dates of those reports were, let's see, June 30th of 2015, August 12th of 2015, December 3rd of 2015, July 13th of 2016, September 15th of 2016, January 4th of 2017, March 16th of 2017, and August 2nd of 2017. There were 8 court reports, and basically in the reports, it's titled Indian Child Welfare Act. Mr. I'm not trying to say the names, so I apologize for that, for protecting the identity of the child. The respondent father reported he's affiliated with the Cherokee Indian tribe in 8 reports. The trial court in 6 separate.
Excuse me, Mr. Ewing. Did he? I don't have my copy of the reports in front of me. Did the report use the word affiliated?
Yes.
So basically, at least my understanding of the way these reports in practice tend to get written is, it looks like there's an initial report, and then the practice is to just add to that report rather than to rewrite a completely new one every time. Is that understanding consistent with what you've seen in your practice?
Yes, sir.
So essentially what we've got is we've got a series of reports that are just an initial report that has supplemental information added into it at different times, right?
But we have more than that, because we have 6 court orders that acknowledge that they.
But I'm talking about in terms of the way these court reports are drafted. I understand that each time they're submitted, what typically tends to happen is that the court allows the admission of the report into evidence, and then that report is before whatever judge is presiding in the particular session.
Correct.
Right. And so what we're doing is, in essence, at various hearings, the same information is before the court multiple times. It's not new information. It's essentially the same information that was available at the time the first report was submitted.
Yes, sir.
And what exactly does that report say? It says Indian roots.
Well, the initial May 4th child family team meeting, apparently there was a meeting with the social workers and the parents.
That was the way I read it, yes.
And the respondent father indicated he had Indian roots in that report.
What is your understanding of what roots means?
Well, I mean, you're related. You have ancestry that you're related to who you're saying.
My understanding, and I really acknowledge I am no expert on this piece of legislation, but it looks to me as if Indian child is a defined term.
Yes, it is.
That to be an Indian child, you have to be either one, an enrolled member yourself, or two, the child of an enrolled. Is that your understanding as well, or am I missing something?
That is correct. But before the case starts, the way the statute reads, if the court knows or has reason to know that a child involves an Indian child. And so the court may not have 100% proof or have to make a determination yet on whether that child is an Indian child. That's why this whole notice process is set up.
Is it your contention then that anytime there is any reference to the possibility that the child might have any Indian or Native American ancestry, that then triggers the notice requirement of 1903 or 1912A?
I would think on most situations it would. And the reason why is this. If I say that I am a member or affiliated with a tribe, due to this, there's a likelihood that my child may also be a member of that tribe.
Let me ask you a question. Can you hear me?
Yes.
Okay. In the report that I think was dated June 3rd, 2015, making reference to that May meeting, I have it in front of me. It's at the record, page 24. Says that the father reported he's affiliated with the Cherokee Indian tribe. I'm quoting from the report here. However, he has not provided the social worker with necessary information to further investigate. So my question is twofold. One, do you think, is that enough to trigger the notice requirement, just that alone? And if not, what else needs to be done? And also, what's the significance, if any, of the part that says that he had not provided additional information?
Okay. I think the way the law is, there's a Court of Appeals case that finds the same thing, that once you indicate that you're a member or affiliated with an Indian tribe, that triggers the notice requirements automatically. There's no other burden on the parent. And the reason why the courts, and some of the cases I cited from North Carolina, the AP case, but also some of the out-of-state cases that have reviewed this, is the only way to determine tribal membership is the tribes themselves. They're the ones who ultimately determine their membership. And so that's why notice is required to go in. I do want to also note that some of the cases that you have were done prior to 2016.
Let me jump in just a second with a follow-up to that, if I may.
Mm-hmm.
So in this particular situation, apparently notice has been sent to 3 different Cherokee tribes. Are there more than 3? And if there is a quote affiliation, why is it not the father's responsibility to then direct the court? I mean, if he's quote affiliated, then you would think that he would have specifics with regard to the tribe with which he's affiliated? Why does he not have more responsibility?
Because the ultimate issue is whether the child is an Indian child.
The only way to find that out is to pursue the parent's alleged affiliation, not by checking a national database or, what if he had left out the word Cherokee? What if he just said, I have Native American affiliation?
Okay,
How in the world do you figure that out?
That would also trigger this provision, and there's a Bureau of Indian Affairs, which Youth and Family Services would then contact and then find and try to investigate whether this child is in fact an Indian child. So there are situations where somebody says, I just have Native American heritage. It still triggers it, and you go through the Bureau of Indian Affairs.
Let me also, are you still maintaining that this child fits the definition of an Indian child, or has that already been determined that this child does not fit the definition of an Indian child?
I don't think it's been determined.
Well, you've gotten the denial of 2 of the tribes. You have no information from a third. What else is the court to do?
Okay, well, what's supposed to happen? First of all, let's talk about the notices. I don't know if the court reviewed the notices in the motion to dismiss. The notices only give notice of the foster care placement case, the dependency case, the January 2nd, 2018 juvenile petition. It did not give the Indian tribe the notice of the termination case.
Well, that has nothing to do with whether the child is a quote Indian child. That's a determination based on their records, regardless of the status of the proceeding.
So 2 of the tribes said they are not members of that tribe. We now have 1 tribe, I think it was the United Kiowa Nation, that did not respond. They still have not gotten notice of the termination case. Even in that,
well, they're not entitled to notice of the termination case unless it is an Indian child. If it is determined that this is not an Indian child, then it doesn't even implicate the Indian Child Welfare Act.
I think you're skipping a step respectfully, because the court, if they know or have reason to know a child is an Indian child, that's when it's implicated. And so there's a code of federal regulation that came out in 2016. It's 25 CFR 23.107. I cited in my brief. It puts the burden on the court if they have reason to know. Under that code of federal regulation, the court is required to ask all the parties if they have any reason to know if a child's an Indian child. And then subsection B, I think, is significant for this court to look at it, and I'll just read it. It says, if there's reason to know the child is an Indian child, but the court does not have sufficient evidence to determine that the child is or is not an Indian child, the court must, and I go to subsection 2, treat the child as an Indian child unless it's determined on the record that the child is not the definition of an Indian child. So
Let me ask a follow-up to Justice Newby's question. Is it your position that there's a difference in the treatment of the proceedings that began in 2015 as opposed to 2018 after notice was given? I understand your argument that the court just has to have a reason to know, and then it triggers the notice requirement, and that did not happen in 2015, as I understand it.
Right.
And so what is your position about what should happen to proceedings that happened at that point, and did it change at the point when a notice was sent to tribes?
Okay. No notice was ever sent, even with the documents in the motion to dismiss at the 2015 hearing. What happened in 2015, there was 2 juvenile petitions. The 2015 action the respondent mother ended up getting custody of these kids. And the kids moved down to Florida. However, there were some issues in Florida, and their version of YFS took the kids. And so Mecklenburg County filed a second juvenile petition. So we have two separate actions where they then filed a juvenile petition and got another order for non-secure custody requesting foster care placement. I don't know if that answers your question. I don't know if I did.
Well, was notice given to the Indian tribes after the second one? And when was the second one that you're referring to?
No notice was ever given.
Okay.
After I wrote my brief, that's when notice was given. After the hearing, so it defeated the whole purpose of the statute to first determine whether the child's an Indian child and to allow the tribes to intervene. But also to tack back, I forgot which justice asked me this question. Was the notice sufficient? It never gave notice to there's one tribe that did not respond. It did not give notice to the termination case. So the court's got to understand Indian tribes have a right not to intervene, even if their child is a member of an Indian tribe. So
what are you contending should happen at this point?
well, there's no jurisdiction in the case. The statute 25, let me see here, 25 U.S.C. 1912. The plain meaning at the last sentence of the statute says, no foster care placement or termination of parental rights proceedings shall be held until at least 10 days after receipt of notice by the parent or Indian custodian in the tribe or the secretary. So until notice is given, Congress has already set out there's no proceedings to be held until proper notice is given.
I want to ask a slightly different question about the impact of the notice that was sent and was attached to the motion to dismiss. Doesn't that mean that the question of whether or not there was enough information here to trigger a notice requirement is actually moot for the purposes of this case, because notice now has been sent and the only issue left to resolve is whether or not is your jurisdictional issue, whether or not the failure to send the notice earlier divested the court of jurisdiction. And in particular, I'm wondering what you make of the Court of Appeals precedents, including the one that you submitted with your notice of additional authority, because the Court of Appeals in these circumstances has just been remanding to give notice. They haven't said, oh, there's no jurisdiction at all.
Correct. That's what some of the older cases are saying. But I will say this. This court has constantly held that you cannot correct jurisdiction. Either the court has jurisdiction or it does not have jurisdiction. And so I know there was a case from South Dakota that had the same similar issue. It realized that you can't hold the proceedings. Congress has established when state courts have jurisdiction over these cases when an Indian child may be involved in the case.
And so then just going to the question of whether the federal law seems to imply that there's no jurisdiction, isn't that in tension with the fact that section 25 USC section 1914 actually says that if there is a failure to comply, it doesn't say that the proceedings are therefore the state court no longer has jurisdiction, but it says the tribe or the individuals involved can petition to invalidate. And it seems to me that if the federal law is saying, well, if you don't do what we told you to do, then you can petition to invalidate, is different from saying there's no jurisdiction from the outset if you don't comply with the notice.
I took it a little differently. The way I look at it is you can challenge jurisdiction at any time. And so that statute is not barring a parent or Indian tribe from challenging jurisdiction at any time in the case.
And I guess my other question about the federal statute is the earlier in that, so 25 USC 1911 says that state and federal courts have concurrent jurisdiction in these circumstances. So it doesn't say that, I mean, the statute doesn't say that if it's an Indian child, then state courts no longer have jurisdiction. It is concurrent jurisdiction here.
I think you got to look at the whole statute, because let's talk about the emergency circumstances. If there's an emergency circumstance, there's 25 U.S.C. 1922, it allows the state to be involved in the case. It doesn't bar them from doing that, but he's still got to give notice. You can't proceed with the hearing until you give proper notice. The statute is clear on that, whether it's the underlying juvenile case where they're seeking foster care or the termination of parental rights case.
It just seems to me that don't you have to be an Indian child before you can petition to invalidate a proceeding that occurred without notice?
No, because under the Code of Federal Regulations, which they promulgated in 2016, if a court just has reason to know, then they're supposed to take the next step and to give notice and to make a determination. So before you begin the determination, which just makes sense, right? You want to determine whether this child is an Indian child or not before you go forward. You want to make sure that, hey, is an Indian tribe a party to this action? You want to do that at the very beginning of the case.
What's your response to the DSS position that there's no need to vacate these orders that have already been entered because it is, if anything, merely a deficiency of notice? And if the tribes that may be involved choose to get involved, then matters can go forward accordingly, but there's no need to automatically say that there is no jurisdiction after these orders have been issued because of the fact that the tribes may choose not to be involved or otherwise intervene.
The problem with that rationale is this. One tribe has not responded, at least to the foster care notice that they've given, the notice of the underlying juvenile action in January 2018. So you rule this way today, and you go ahead and you allow them to move forward with the case. The tribe at any point can invalidate the action. Even if the child has been through the adoption processes, they never had notice of the termination proceeding.
Well, Mr. Ewan, let me interrupt you just a second, because if you look at section 1914, you just said the tribe can invalidate the action. At least the way I read it, it says any Indian child. So essentially, it's either the child who has to be shown to be an Indian child, a custodian of an Indian child, or a tribe with which the Indian tribe is affiliated, may petition to invalidate such action. That doesn't seem to me to say, first of all, that you can petition unless there is an Indian child involved. So that there's not an Indian child, then I'm not sure that the 1914 petition can be filed. And then secondly, it says you may. It also leaves open the possibility that there may be relief other than invalidation. How is that consistent? I know you talked about this a little bit with Justice Earls, but tell me as directly as you can why that is a jurisdictional type statute rather than an error correction type statute.
Like, I remember a number of years ago, there were cases where our state statute, when you file a termination action, requires you to put the custody order when DSS or YFS files a termination action, to put the custody action, the copy of the order behind it. And we were challenging the issue that you didn't file the state statute because you didn't attach the custody order to it. And this court held that that was not a jurisdictional error. It's based on a prejudicial standard. The difference here is this statute clearly says in the third sentence that no proceedings can go forward. Not the underlying neglect proceedings, not the termination, until notice is given.
Well, usually when there's a jurisdictional defect, an order entered without jurisdiction is simply void. And so there's no, everybody can act like it's not there, and there's no need to formally invalidate it. 1914 seems to me to suggest, first of all, there's some prerequisites to who's entitled to challenge it in the first place, which I'm not sure would be present if you had a jurisdictional problem. And then secondly, seems to allow the possibility that the relief granted might be something other than mere invalidation of the order. How is that consistent with a jurisdictional analysis that indicates simply the order had no effect in the first place and can be disregarded by everybody?
The first part is if you require a parent or a party, just say IFS gets information when they do their investigation that a child's a member of the Cherokee Indian tribe. If you make the requirement that you have to prove that the Indian child is in fact an Indian child to start with, you defeat the whole purpose of the statute. The whole statute is to protect the Indian child and to give notice. Right now, we don't know if this child's an Indian child or not. We got 2 tribes that come back that said that it is not involved. Then we have a 3rd tribe that's not responded.
Is there any time limitation upon which a tribe has to respond before a court can proceed?
Well, the statute says,
or is the court in a situation in which we find ourselves where inquiry's been made and after some apparently extended period of time, no response is provided? Is the court just held in limbo?
what I have cited for you in the memorandum is a case, there was additional authorities, in Ray GT. The Bureau of the Secretary, the Department of the Interior, excuse me, has promulgated rules that says, hey, if you don't get a response back from the Indian tribe, you're to call the Bureau of Indian Affairs and send out multiple notices. Then once multiple notices are not responded to, the court can move forward. So I cite that case, and I'm running out of time here, but they go over that analysis in that case from the Court of Appeals. All right, I know I'm out of time. Thank you.
Thank you, Mr. Ewing. It's my understanding that Ms. Jamison and Mr. Phillips will split the time. Ms. Jamison will argue for 20 minutes and Mr. Phillips will argue for 10.
Yes, thank you. May it please the court. My name is Stephanie Jameson, and I am here today representing the petitioner appellee in this case. Mecklenburg County Department of Social Services, Youth and Family Services respectfully ask this court to affirm the court's March 15, 2019 order terminating the parental rights of the appellate respondent father and to not invalidate all the orders in the underlying case. There is no dispute that DSS sought foster care placement of the juveniles via involuntary child custody proceedings in a North Carolina court. As to the issue of notice, in this matter from June 2015 to August 2017, DSS's court summaries did note the respondent appellant father reported being affiliated with the Cherokee tribe. Before December 12, 2016, the father's mere belief that the juveniles were Indian children via his reported affiliation did not meet the father's burden of showing ICWA applied. This is noted in North Carolina appellate cases In Re AR and In Re LWS. During that time, the burden was on the party invoking ICWA to show that the provisions applied in the case. Therefore, the trial court did not have a duty to ensure notice was sent pursuant to ICWA. However, effective December 12, 2016, federal regulations 25 CFR 23.107 shifted the burden to state courts to determine if a child at issue was an Indian child. This is noted in North Carolina appellate case In Re AP and the footnotes of In Re LWS. Therefore, it would appear after December 12, 2016, the father's mere belief was sufficient to put the lower court on notice that Indian children may have been involved in the matter. Based on that, the court was to ensure notice was sent to the proper tribes pursuant to ICWA, and the tribe would determine if the juveniles were Indian children or eligible for membership. That standard is noted in Re AP, the footnotes of In Re LWS, and addressed in other jurisdictions in Re MCP, In Re JT, and In Re Antoinette. Prior to this matter being appealed, notice was not sent pursuant to ICWA. The proper remedy for failure to comply with ICWA's notice requirement, as in this matter initially, would have been to not reverse any orders and to remand for the trial court to send notice, and then based on the results, the trial court would determine if it had subject matter jurisdiction and comply with ICWA accordingly. This standard is noted in a North Carolina case In Re AP. In that matter, the court remanded for notice to be sent, and the remaining issues on appeal were preserved pending the remand outcome. Other cases in other jurisdictions, In Re MCP, a Vermont case, that court also remanded for the trial court to send notice to the tribe. However, the court went on to rule on the remaining, I'm sorry.
Let me jump in for a second and ask you, how do you reconcile that with the provisions of 25 USC 1914 that says that any Indian child who is the subject of an action or termination under state law, any parent or Indian institution and the tribe may petition any court of competent jurisdiction to invalidate such action.
I apologize, Your Honor. You were breaking up, but if I understand your question, this would apply if someone was an actual Native American child, was an actual Indian child, or Indian parents, that they could petition the court to invalidate the court orders since they would not have been given proper notice under ICWA.
So does that substitute for the having reason to know provisions of the other section?
I think the change was regarding the reason to know in terms of initially the standard was a mere belief was not enough. In this case, it was a mere belief by the respondent appellant father. And so initially pre-December 12, 2016, no, that was not enough based on the case law cited. However, after December 12, 2016, that shift did occur. And so, yes, the court would have been obligated to send out notice at that point.
Well, my question is more to the remedy. If notice was required to be given and it wasn't, it looks as if the section 1914 permits a petitioner to seek to invalidate any action that was given in violation of the notice provisions.
It does, that is correct. And then it will be up to the court to make that determination of if that is a proper remedy.
So is that what you're saying should occur on remand?
What I'm saying, no. What I stated would be the proper remedy for failure to comply with ICWA notice requirement in this matter would be to not reverse any orders and to remand for the trial court to send notice, and then based on the results, the trial court would determine if subject matter jurisdiction, if it has subject matter jurisdiction, and comply with ICWA accordingly.
So are you agreeing that a remand should occur here?
I am stating that based off of case law, that has been the practice. When you have a scenario such as the one in this case, that has been the practice.
Let me ask it as directly as I know how, because I had the same question that Justice Hudson just asked you. Are you arguing that in this case, on this record, the court should enter a remand order?
That is not what I'm arguing. What I'm arguing is that initially, prior to us sending out notice, that would have been the argument, because the respondent appellant father's brief is to basically say to invalidate all of the court orders in the underlying case. And I'm trying to point out that that has not been the practice. The scenario fits this case.
I understand that. I guess the question, if you became the court for purpose of this case, how would you decide what we've got before us today? Would you remand the case in accordance with the discussion that you had, or would you do something else?
Oh, no, I would note that the issue in this matter has been addressed ultimately. As noted in my, in the petition.
Hold on just a second. Just if I don't interrupt you, I'm not going to follow you, and I want to make sure I am.
Sure.
So are you saying that it has been addressed because of the information contained in the motion to dismiss as moot that several of the colleagues have alluded to?
Yes, Your Honor.
So is your ultimate argument then that we should dismiss this case as moot?
Yes. I believe that the issues in this matter has been addressed. And as you stated, as noted in the petitioner appellee's motion filed with this court on May 15th, the father did report affiliation with the Cherokee tribe, and DSS did send notice to 3 Cherokee tribes on August 1st, 2019, received a response from 2 tribes, noting that the juveniles were not members, nor were they eligible for membership. The 3rd tribe did not respond after receiving proper notice via certified mail in August of 2019. On February 19, 2020, the trial court found ICWA did not apply and the time had run for the tribe to respond. So therefore, I would argue that it appears this matter is now moot and I would ask for the appellant's appeal to be dismissed. Now, I do note that the appellant filed a response to our motion seeking for it to be dismissed, arguing that the trial court lacked jurisdiction. However, in this matter, the trial court could exercise its jurisdiction despite initially failing to comply with the notice provisions of ICWA. Because even the North Carolina appellate case in Ray AP, that court remanded for notice to be sent and deferred to the trial court in assessing jurisdiction when it stated, in the event that the trial court concludes on remand that it lacks subject matter jurisdiction, then it will be required to dismiss the petition. In a case cited by the respondent appellant father, in Ray Antoinette, that court stated that the less than 10-day notice to the tribe was harmless error, especially since the BIA responded and determined that the juveniles were not Indian children, so it would then apply. And the court said,
it was notice given to the Bureau in this case?
yes, it was given after notice, after the appeal was filed. The notices were attached to the motion, and it was sent, for each tribe, it was sent to the actual tribe and then their regional director. So every single one was sent to 2 different places for each tribe.
And no response was received from one?
That is correct. There was no response received from the 3rd tribe. And I liken this case to the Ray Antoinette case, in which that court ruled that the less than 10-day notice to the tribe was harmless error because the tribe did respond and determine that the children were not Indian children, and so ICWA did not apply. And that court did not find that the 10-day period notice required by ICWA was jurisdictional error. In fact, that court stated, the very fact that notice problems are sometimes deemed harmless error in ICWA cases indicates such an error is not jurisdictional. And if an error were to strip a court of its jurisdiction, a dramatic proposition for which there is no precedent in other areas of the law, then the juvenile court would lose all authority over the dependent child in its care, requiring immediate return of the child to the parents who have demonstrated at least temporary unfitness. I would argue that this matter has been addressed. The notice error in this matter can be deemed harmless error, especially in light of the fact that 2 out of 3 tribes responded and noted ICWA did not apply, and the 3rd tribe did not respond in over 6 months, which is far past the 30 days the tribe has to respond pursuant to ICWA, and that is noted in 25 USCA 1912. And
so I just want to, so I apologize to interrupt you, but I just want to be clear from what you're just saying. It sounds like you agree that we have to reach the jurisdictional issue, and you're arguing that the failure to originally send the notice doesn't divest the court of jurisdiction.
Exactly.
And thank you. And just to clarify one slightly different point, the Bureau of Indian Affairs is different from the tribal office or even a regional tribal entity. And as I just want to make sure I'm clear about the record, given what was attached to the motion to dismiss the appeal, it didn't go to the Bureau of Indian Affairs, it went to the tribe and to the regional organization.
That is correct. We did send to the tribes, and we received certified, signed certified mail from all of the tribes that we sent the information to. And so I did just want to note that according to the statute, they have 30 days to respond. And that is noted in cases such as Ray AP and Ray CP. Those cases were the cases that were in effect when the trial court made its ruling, even though there has been a more updated recent case attached to the memorandum of the appellant respondent father. That case became in effect after the court made its ruling in this matter. So really the cases that apply in this matter would be the standard noted in Ray AP and Ray CP, which gave the tribes 30 days at max to respond, and then it allowed the court to proceed with hearings. The reason why we would argue that this matter is moot, because the North Carolina appellate case in Ray Stratton noted whenever during the course of litigation it develops that the questions originally in controversy between the parties are no longer at issue, the case should be dismissed. In this matter, the questions in controversy was 1, should notice have been sent? And 2, were the juveniles considered Indian children that would trigger compliance with ICWA and possibly result in the trial court losing jurisdiction over the matter. We are in agreement that notice should have been sent, and it was eventually sent. Based on the response from the 2 tribes and the lack of response from the 3rd tribe, the court determined that the juveniles were not Indian children for purposes of ICWA, and ICWA did not apply. Additionally, this means the trial court properly had jurisdiction over this matter during the entire life of its case, and its judgments and orders entered in this matter should remain intact.
I want to follow up just a second on a couple of questions from Justices Hudson and Earls. Do you read the Indian Child Welfare Act to require notice to be sent to the Bureau of Indian Affairs in every case? And if so, wouldn't we need to remand to the trial court for that to occur?
I do not read it to say that, but however, if that is how Your Honors read it that way, then I would say then that would be the proper remedy then for it to be remanded. But I would argue just for notice to be sent to the tribe that didn't respond for purpose of that, because you do have 2 tribes, even though it may not have been sent to the BIA, it was sent to the tribe, which is what the case law and the statute require, that the tribe makes the call. And we have 2 tribes that made the call. And they stated that the juveniles, not only were they not members, but they also were not eligible for membership. And so I think that has to be honored, that they have already spoken. It is that remaining tribe that received notice, signed for the certified mail, but hasn't responded in over 6 months.
What's your position on the father's position that any orders that are entered before notice is given would be a nullity, not necessarily as I'm coming at this now from the standpoint of jurisdiction, but from the standpoint that in terms of looking at everything for the children involved, that the statute would mandate that there would be notice even before matters lead to any orders of the trial court?
I go back to N. Ray Antoinette. In that case, they had sent out notice. Basically, I think it was like they sent a notice the day before they had the TPR hearing. They conducted the TPR hearing, the matter was appealed, and the Court of Appeals, by the time they heard it, had received a response from the BIA saying that these children were not Indian children. And so then they deemed that to be harmless error. The Court of Appeals did not say just, and this is a California case, granted, but they noted they were not going to remand and send it back just because of that 10-day notice failure. They deemed it to be harmless error in light of the fact that the tribe responded.
Is it your position that no matter where it occurs along the way, that it does not necessarily need to be a response to notice at the outset, if in fact the tribe, the Native American tribe, ultimately says that there is no eligibility or otherwise that the tribe will not be involved? It doesn't have to be at the outset. At some point, if the tribe declares there is no involvement that it wants to have, then that is sufficient and would not nullify anything that took place before.
As I read the case law and the federal regulations, it should occur at the outset. However, if it doesn't, it can occur at a later point in time. And then once you have done that, you have to see whether or not ICWA does apply. And then if ICWA does apply, then you have to determine whether or not, how you're going to fix it. Are you going to void an order? Are you going to go ahead and have the tribe come in? Or is the tribe going to simply say, we don't want to be involved? And I think that piggybacks off of the appellant had cited 3 cases in which the court did actually reverse and vacate orders for failure to send notice. However, the difference in the cases that the appellant cited in N. Ray EMG, N. Ray NAH, and N. Ray Desiree was that all of those children in the trial court level were determined to be Native American children. N. Ray EMG was a North Carolina appeal case. The child was an Indian child and lived on tribal land with Indian parents. And even in that matter, the court didn't just vacate and vacate all the orders. The court simply vacated just the PP order and remanded for further hearings to make necessary findings with ICWA. So it didn't just say, well, we're going to strike all the orders in the underlying case. The South Dakota case in In-Rate NAH, that was an Indian child that was determined to be one at the trial court level. The mother was enrolled in a tribe. And again, the court did not vacate the orders. It just simply reversed only the TPR order and remanded because it believed an adequate notice to the tribe court divested the court of jurisdiction to TPR the parents. In-Rate Desiree, again,
I'm sorry to interrupt.
determined to be an Indian child.
I have a follow-up question to make sure I understand your argument about the notice to the tribes and or the secretary. As I understand it here, there were 3 notices sent in 2019 and one tribe did not respond. Is that correct?
That is correct.
But no notice was sent to the secretary?
My reading is that the notice would be sent to the secretary if someone came in and said, I am a member of a Native American tribe, but I don't know which one. So then you would send it to the secretary and the burden would fall on the secretary to reach out to the other tribes within a 10-day span to determine, is this person enrolled or eligible for enrollment in your tribe? Once that tribe says, oh yes, that is the case, then they could petition the court for an additional 20 days. That way they could gather their information and be a party to the proceeding.
So it's
No,
your
the secretary wouldn't be upfront.
that they did not need to send notice here to the secretary.
Correct, because he had identified the Cherokee tribe. So notice would have just been sent to the tribe that he identified. And there's 2 in Oklahoma and 1 in North Carolina, Cherokee.
Okay, just wanted to make sure.
Oh, no problem. And so I just wanted to highlight that all of the cases that were cited in the appellant's brief that remanded or vacated, all of those cases involved an actual Indian child as defined by ICWA. But none of those cases vacated all of the judgments or the orders in the matter as the appellant is asking for in this matter. And also they differed from the case at hand because in the lower court, there was no determination made by any tribe or court that any parent was a member of a tribe, a parent or a child was eligible for membership, or that the children were Indian children. What has been the practice has been, again, for normally remand for the scenario that we have in which there's a mere belief. And for the Vermont cases, In-Rate MCP and In-Rate JT, the court stated it did not find reversal of the orders to be warranted where the only error was failure to provide notice, and MCP said there was no showing that ICWA applied. In-Rate JT said there was no strong showing that ICWA had applied. So that has been the standard practice for this scenario, is normally to remand. We argue that we've already done what would have been asked of us for the remand, which is to send out notice, and we have received the responses from 2 out of 3 tribes. And so we would be asking for that the court would grant our motion to dismiss the appellant appeal for mootness. However, if the court does not deem that remedy to be appropriate, then we would ask this court to still affirm the court's March 15, 2019 order terminating the parental rights of the appellant respondent father and to not invalidate the orders in the underlying case for the reasons previously stated. I think the court can do in this matter what was done in the prior North Carolina appellate case, which was In-Rate AP. It remanded for notice to be sent and the remaining issues on appeal were preserved, or it could do what was done in a Vermont case, In-Rate JT. It remanded for the court to give notice that if the trial court responded, then it directed for further notice consistent with it will be necessary. Otherwise, it went ahead and affirmed the TPR order. Are there any questions? I'll be more than happy to answer.
I think you were going to share your argument time with Mr. Phillips.
Yes. I'm happy to do so now if there are no questions for me. Thank you.
All right. Thank you, Your Honor. May it please the court. My name is Matthew Phillips, and I am the appellate advocate for the guardian ad litem. We also joined Ms. Jameson in requesting that this appeal be dismissed as moot because we believe that the jurisdictional question has been resolved through the notices given to the tribes. But if not, we would ask that this matter be remanded to the trial court to determine whether jurisdiction exists in this case or not. I would note that.
So you, like Ms. Jameson, are conceding that it was error not to send notice at the time, at least at the time the 2016 regulations became effective?
Yes, Your Honor. If not full notice, then at least some sort of verification. The trial court needed to do some level of verification.
There's no verification requirement. It's just either you've got some reasonable grounds and therefore need to send notice or not. Is that the way the statute reads as you see it?
And the part of the federal regulations that lay out the whole notice, all notice required to the Indian tribes to determine whether they are, or to allow them to intervene, is separate than the language that requires some verification if the court has a reason to know. The verification requirement is in 25 CFR 23.107B, and it says that the court must confirm by way of a report, declaration, or testimony included on record that the agency or other parties due diligence to identify and work with all the tribes. The full notice requirements are included in 25 CFR 23.111. So that it would seem that verification is separate from notice, and notice is required if with the full 25 CFR 23.111 requirements is required. When they know that the children are Indian children, then they have to do their best to verify with whatever tribes. It's been remanded to the trial court to determine whether the children are in fact Indian children. When it's uncertain whether the children are Indian children, that all the previous orders in the case need to be vacated. The two or three cases cited by Mr. Ewing to that effect have stated have had children that they knew in fact were Indian children, and so it was either that perhaps the best course here would be to remand to trial court to determine whether the children are in fact Indian children. If this court is not satisfied with the notice or the verification requirements have been satisfied. And I would just also note, as a practical matter, it would seem to not be in the best interest of the children to have to vacate all of the orders in this.
Mr. Phillips, we're going to ask you to, Mr. Phillips, Mr. Phillips, we're going to ask you to stop your
Yes.
argument for a moment. We are having a
Yes.
difficult time connecting with you, and so our IT person, Fred, will be in touch with you as to how better to connect, or maybe have you connect by phone.
Hello? Hello?
Yes.
You, Mr. Phillips, can we hear you?
I can hear you now.
Okay, you can hear me.
Yes, Your Honor.
All right, and we can hear you. I think if you could speak up just a little bit.
All right. Yeah. Yes, Your Honor.
Okay. The clerk is adding time to your remaining time. Much of your argument we were having trouble hearing, and so you have 5 minutes 30 seconds remaining on the clock.
All right. Thank you, Your Honor. All right.
Are we ready to go forward, Fred?
We should
I think
be
we're
good,
ready,
Donna.
Mr. Phillips.
All right. Well, I'll start from the beginning again. Please the court. My name is Matthew Phillips, and I am the guardian ad litem attorney advocate. The question for this court today is whether the court should dismiss this case because there's insufficient evidence to determine whether the children fall under ICWA. Let's see. Let's see. As Ms. Jameson noted, anytime this issue has come before the Court of Appeals, they have not dismissed the case when there was a question about whether the children were Indian children. They have remanded it to the trial court to make a determination whether the children were Indian children, and that has happened regardless of before or after the change in federal regulations. And mentioned by Ms. Jameson and Mr. Ewing. Let's see. And so, and also we would note that the requirement that all previous orders in the case be vacated is the court cannot determine whether the children or Indian children would appear to be a new holding. It doesn't appear that any state court has previously held that. As Ms. Jameson also noted, the cases by the appellant appeared to be no dispute about whether the children were in fact Indian children. In this case, there is at the very least a dispute about whether the children are Indian children, and some need to verify whether the children are Indian children. So the appellant cited NRA, NAH, and that in that case it appeared to be established fact that the mother was a member of the Sioux tribe and the father associated with the Crow tribe, which is different from this case, in which there is no proof that the children are Indian children. And also, as the appellant cited NRA Desiree F. for the California. Again, in that case, all of the previous orders were thrown out, but that was because there was no dispute that the child was in fact an Indian child. In this case, there appears to be, at the very least, a good faith dispute about whether the children are Indian children. Let's see. Yeah. As I previously stated, I believe that either the correct remedy in this case is to dismiss this appeal as moot, because the trial court has taken the proper evidence at this point to determine that the children are not Indian children, or to remand to the trial court to determine whether the children are in fact Indian children. Does the court have any questions for me?
I don't think so, Mr. Phillips.
Okay. Well, then I would just conclude by saying that it would appear that the proper remedy in this case is either to dismiss the appeal as moot or to remand to the trial court for further evidence as to whether the children are in fact Indian children. Thank you.
Thank you, Mr. Phillips. Mr. Ewing, I believe you have just a few more seconds.
When reviewing this case, I think it's important for this court to know that in 2016 was a big change, or not even a change, but kind of where the Department of Interior was trying to standardize what was going on with this Indian Child Welfare Act. I've cited you the case of NRA H. They cited the case of Antoinette P. These all happened before 2016. Different state courts were ruling on this act differently. So they issued the Code of Federal Regulations in 2016, which is that 25 CFR 23.107, I would really ask the
Mr. Ewing,
Yeah.
Mr. Ewing, your time is up.
5 minutes are up.
Yes, you only had a few seconds.
Okay. I'd ask the court to do that because I think the things have changed since then.
Okay, thank you, sir. Thank you to all counsel, Mr. Ewing, Mr. Davidson, and Mr.
Thank you.
Phillips. We appreciate you participating in this historic virtual arguments. Thank you.
Thank you. Have a good one.